And by the way, anybody who's listening to this podcast, if you're thinking about going out on your own, do so. Probably one of the best things I did.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and noble practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share the part 2 of this conversation with Deborah Bogaards. I know that you spent a good portion of your initial years on the defense side, and then at a certain point, you also started taking plaintiffs' cases. And I wanted to learn a little bit more about the decision, why you decided to expand your practice some.
I don't know what led to the first cases. They were in about 2002 that were being referred to me from friends. They were usually plaintiffs' counsel friends who had smaller cases to give out, although some of them were in elder abuse and wrongful death. And as I started doing some of them on the side, let's say, I learned that a few things about myself. One, I was brought up with this idea of tikkun olam, which it means to repair the world. So I've always liked to give back and help people. I found that it was incredibly nourishing to do a plaintiff side case, do well on it so that my client felt that he or she had been heard and vindicated for what happened to them. And I really got a lot of pleasure from it. So I think I started doing more. I was doing 2 wrongful death cases from elder abuse case, skilled nursing facilities. And I used the same tools. I was using my medicine to figure out, what had happened to them. And yeah, it just started kind of growing that way. Friends of mine heard that I was taking more cases. And so by, let's say 2010, and when I pivoted with a new partner, it seemed like 90% of my caseload was plaintiffs. And I felt that the defense cases, I kind of had seen them before. I wasn't getting as much satisfaction from doing them, and it just naturally helped when I was building this practice. And so by 2017, when I went out on my own, finally, and by the way, anybody who's listening to this podcast, if you're thinking about going out on your own, do so. Do so sooner than I did. Probably one of the best things I did. Anyhow, so from 2017 until I closed my practice at the end of 2023, I did solely plaintiffs' cases. And you get so much reward from that, don't you? It's a great feeling. My clients have stayed with me. Not only did they refer other friends, but I could just see, as you probably do, that when you help them settle a case, I've tried one plaintiff's case, but when you help them settle it, it's just this relief that washes over them. They're able to get on with their life. They don't have to deal with the emotional roller coaster anymore of litigation. So it just kind of naturally evolved.
I will follow up on going out on one's own, because I think that's a wonderful topic to mine. Before we get there, I do want to ask a little bit about whether you feel working both sides improved your lawyering overall, having to look at a case from the opposite side.
Absolutely.
And can you unpack that a little?
Absolutely. And by the way, as you know, I teach over at UC Law a course on negotiation, and my students come to me because I try to help them with their jobs. And they'll say, well, what do you think about working for defense and then crossing over to plaintiffs? And my messaging is it's great training ground to work for defense, maybe stay for 2-3 years and then cross over to the plaintiff side. So I think the agility that you get from working both sides is amazing. On the defense side, I know how to talk to the claims reps, what they need. They are going to need documentation that may come from informally if the plaintiff's counsel sends you a really good, remember the old-fashioned settlement demand package where you would have medical records attached, exhibits, you would have wage loss verifications, everything you would need to settle a case.
Is that old-fashioned?
It is old-fashioned. It just isn't happening.
Okay. I know I'm taking off on a tangent, but I need to follow up on that. Are we doing something wrong if we're still doing that? Or did something happen in the practice that I'm unaware of?
That would be for me telling you more as a mediator. I don't understand if you're doing plaintiff side, why you wouldn't just give all of that to the defense as soon as you have it. Because we're going back to an understanding from the defense side. I don't look at it as a big bad insurance company always. I'm not an ideologue, but what I see is paper. They need the documentation in order to pay what's fair and reasonable. So what documentation do you have to give them? How do they evaluate the plaintiff's injuries? They may need, let me back up, they may need liability. So first they can hire their own expert if they're questioning causation of injury. But when they get to the injuries, they need to get the medical records. So you either give it to them or they subpoena them. I know many people who aren't giving them the films. They need the diagnostic films for their expert too. So just give them the paper. And then for a wage loss, why not just simply have your, client go to their boss and say, can I get a wage loss verification? And get that information to them. Now, if they get that and they're not fairly evaluating the case, well, that's where I might come in at mediation. But if they have that from the very beginning, then they should be able to evaluate the case from the beginning and get it resolved. So what surprises me, again, I'm probably jumping into mediation. What surprises me is when I see confidential plaintiff's briefs. Why? You're the ones that need to help the defense to see your viewpoint. Shouldn't they have all those exhibits? Why haven't they gotten certain films? So I think when you work on the defense side, you understand what the carrier or headquarters needs. You understand that claims reps sometimes have limited settlement authority. It needs to jump past them. You understand that it's frustrating as hell when you get claims reps whose, their time is up and now goes to another claims rep and might go to a bigger lit unit and then whatever. So you are going to have frustrations. But if you understand how it works, then you would be, at least by the time of a mediation, you would be giving the defense everything signed, sealed, and delivered, mediation brief, all the exhibits, everything that could help you in your case, at least 6 weeks in advance on a bigger case so that they can correct settlement authority. Well, you learn that by working on the defense side. You learn how to take such good depositions, hopefully, because you're doing depositions just about every day. It's a law of numbers. So in the plaintiff's world, you may not be doing them every day. The very significant cases, the partner is probably doing those depositions. Again, on the defense side, you come in day one, you're going to be given depositions, arbitrations. So that helped when I then crossed over to the plaintiff side. What was new for me was hearing my client's story inside of what happened. And some of it is what you can't touch, or you just have to feel it, or it's a gut level thing about how do I show the other side that, like in your cases, the client is an avid cyclist. It's how they derive their enjoyment. It's what they do every weekend. They'll go out to West Marin and now they can't. How did that impact their life? So I think on both sides, you should be good storytellers. But on the plaintiff side, you really have to sell that story so that the defense can understand. They're busy looking for documentation numbers. What are the house specials? What's the wage loss? But you on the plaintiff side have that intrinsic ability to tell their story of how it affects all of their life, their family, their celebrations, their milestones. And so doing both well is, what I got to see.
One of the things that I've heard, and it seems to be less of an issue now, but I had heard in the past that carriers were really not happy with their panel counsel if their panel counsel were also doing plaintiff's work. Did that change at some point?
I think that's true, but I've always bucked the system, haven't I? When I was defense counsel, I was thought of as the outside panel counsel as the expensive one because I'd have a dream team of experts. I would spend literally hours crafting my cross-examination for trial. I can remember taking one neuropsychologist from Oregon's deposition over the course of 20 hours. And then I always laugh because I go to trial and you have to give a judge trial estimates. And I would say, Your Honor, I would need up to 1 hour for cross-examination of this expert. And my opposing counsel would laugh and say, you took 20 hours in deposition. And I'd say, correct. But from there, I could give a very tight cross-examination. So
we talked a little bit about your opening your own practice, and your comment when that came up was, if you're thinking about it, don't just think about it. And I'm paraphrasing.
Yes, that's right.
I know a lot of people are thinking about it, either in the back of their mind from the moment they start, or at some point when they've reached a point in their career where they want to be their own boss.
Yeah.
So how did you start putting those into play, and what do you think you did right? What do you think you could improve on, like doing it sooner?
Yeah. One, I think I should have started my plaintiff's practice at least a decade sooner, at least. Two, I always felt that I needed to have a partner. Part of that was because I was doing insurance defense, and they like to have a firm that has more than one at the top. But as I was working, I was getting more dissatisfied with having a partner. And, what may happen in partnerships, it happened for me. One person's working harder than the other. That was usually me working harder and differently. I had a certain level or standard that I wanted, and my law partner may not. So finally, when I ended that second partnership, I then went out on my own. And I wished I had done that earlier. I think it's really important for young attorneys to go work for a firm for a few years. I say 3 to 5 years. Ideally, get some training, take a lot of depots, make your mistakes, because that's how we lawyers learn, and watch other styles. And then absolutely, if you want to go out on your own, the steps it took, I already knew from running my firm. I knew bookkeeper, I knew, legal assistant or another associate, but you should maybe take a accounting or a business class at the local city college to just understand law as a business, particularly if you're going out on your own. Have your style. In the plaintiff's world, you're going to be doing intake and looking at so many cases and only taking a rare few. That means you need to have some, experience and understanding of what is a good case and what's not a good case. But the reason I said do it sooner than I did is take that giant step. It's scarier than hell, because all of a sudden you're without a safety net. You're not getting your salary, and just go do it. And you might start out with 1, 2, or 3 cases. Maybe you partner or you share space in an office with, I know some people do, with a more senior attorney who's looking to close their practice. Figure out how you're going to get your overflow. Go to your SFTLA events, network, always network as soon as you graduate from law school. Network, start helping, getting cases with, people like yourself, and then go out on your own.
And on the networking side, do you find that networking in certain areas are better than others in terms of developing a case flow?
I've always had the osmosis theory of life, that I do what I like and it will happen. So I've never had as much a directed way of doing it. But I know for me, SFTLA was a lifeline because there's so many wonderful attorneys in it. And, more senior attorneys are looking to give their smaller cases to someone else. I have always been involved in charitable organizations or causes that I like. So I was on Board of Legal Aid in Marin for 20 years, and I would get cases through legal aid sometimes. I am on American Jewish Committee board, not thinking I got any work from that. I'm on Board of Trustees for UC Law, but just through knowing people and doing what you like, through cycling, through other things, you'll get it. One interesting thing I learned and watched someone do is every time they met somebody new, he would tell them, I'm a personal injury attorney. And that's not something that I knew to do right away. But how else are people going to know that that's what you do when they're a friend of yours to refer the case? So I thought, that does make sense in a more limited way for me, but you have to let people know what you want. So an example, you remember the pipeline explosion? San Bruno pipeline explosion. Everybody wanted to get one of those cases. Those that had websites would put little, feelers out on the website that they do that. And I was just talking about it. I really thought that would be a great case, an interesting case to have. And so I was just telling people, and I happened to mention to my husband, and he ended up getting a lead that I then turned into a client that was a couple who was watching the NFL game at their parents' house. And they were the epicenter for the first pipeline explosion, and she ran out to the neighbor's shed, and that was the second explosion. She passed away. My clients were her parents.
I remember that case.
Right, but that just came from putting it out there that, that would be really interesting. Now, if I just thought it and I hadn't verbalized it, it never would have happened.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. In that vein, I know that there are various organizations, provisors, BNA, other intentional networking organizations. And I'm not bringing those up for the networking piece, but I know that one of the things that they train people to do is to have, what, in essence, an elevator pitch.
Yes.
Hi, I'm Miles, and I'm a personal injury lawyer. Or,
Yes.
Obviously, I don't do it because that's not very flashy. Do you feel like lawyers should, even if it's not flashy, have some sort of way of communicating in a very truncated way? This is what I do, and this is how I can help people
I do. I'm actually a member of Provisors. I got a few cases from them when I was on the plaintiff side that I paid referral fees. So it is a source. Some get even more. I think it's a good exercise that they have. Usually you're getting it from other attorneys who are in the group. And don't forget, when you do personal injury law, for example, you pay a referral fee. So why not tell them about that? And then I did employment law was my second area. I've also done other areas, elder abuse, sexual abuse, some products liability. So, and again, think about it. People will know me personal injury. They forgot that I also did employment law or that I had these other talents, if you will. So you somehow need to figure out a plan for yourself, whether it's your provisors, whether it's the elevator pitch. Sometimes, I might shy away from that. And you might too. You might recoil going, I really don't want to do that. But you should let groups of people that you're in know that this is what you do. The old business card used to do that. We don't do that anymore, right? And we have less occasion that we're all in public together, whether it's a holiday party or that. So one of the things that I felt comfortable doing, and I still do, is I'll meet people for lunch or for dinner. And I found lunches were really good. You and I have had lunches. They give a way to connect. And then you can talk about maybe some of your cases. And as you're talking, which is more natural for me, when you're talking about your cases, I'm like, gee, I didn't know you did a bicycle case, right? Or I didn't know you did that sexual abuse case. And so even your own lawyer friends will learn more about you to refer. So yeah, you've got to figure out something. If it's your elevator pitch, that's really not for me as much. But it did get me to go out and tell people more.
The reason I perseverate on this question about having whether an elevator pitch or being willing to talk about it is I know as a younger lawyer, one of the things I was challenged by was being raised in a way where one was supposed to be humble, not brag, not talk about things. And so it took me a long time before I recognized that you had to talk about yourself at least a little bit so that people knew what they were doing. At what point in your career do you feel like you kind of reached the right point to be able to do that?
Well, remember, I was on the defense side first, so I didn't really have to go out and get business, although I did have private clients. We had the advent of Super Lawyer. I think that came out sometime around in the 2000s.
That sounds about right.
And we started doing the profile ad every year. So that was my first foray into putting ourselves out there. Then when I crossed over and was doing plaintiff's work, I learned how to do a new website. And if you look at all the plaintiffs' websites, they have you, they have me, they have the people right up there, right out front, which we didn't do on the defense side as much. And you're right, you are marketing yourself in a way because people have to trust you. They have to have confidence in you as their attorney. So that was kind of a new feeling. It did feel like a little braggadocio and all of that. Then I joined Provisors. And yes, they have their elevator pitch, but I don't necessarily do that. But what I learned is I have to let people know what I do. They may remember me just from doing personal injury. They don't know I do elder abuse. They don't know I do products liability. They don't know this because we don't talk about it. So I'd find that, for example, my style of individual marketing is to go out to lunch or go out for dinner. And during that time, I get quality time with another attorney, for example, or friend. And I can tell them usually invariably you talk about a case you're working on and you are so enthusiastic or you're frustrated by an expert. So you're talking about it and they go, Miles, I didn't know you did bicycle cases. Of course, you're living under a rock, but you know what I mean? It's just letting people know whatever is your style, but you do have to be upfront about it. I'm not going to be the one to go to a party and go, hi, I'm Deborah, and tell people, although now I am as a mediator. I am doing that. So you just find what style works for you. But for a young lawyer, yes, you're going to have to figure out what works and go out to get your business.
I think that one of the things that you brought up a little bit back that is very important is if you don't like the way you are doing it, that's going to come through. If the matrix tells me that I am supposed to go out and have lunch with people because that is part of how I build business, the person on the other side of the table is going to get that it's not genuine. So your comment about whatever it is, whatever marketing method, networking method that you're doing is something that you need to enjoy. I think that's very important.
Yes. And I did learn something recently. It was called the Sweet 16. And I think this would be great for anybody. The Sweet 16 is you take out your calendar and I didn't do 16 names, but you choose 16 names of people you'd be interested in getting work from, other attorneys that may not know of you as well. And then you figure out a way where for an hour a day, I don't do that, but for some time each week, you think of that person and you may send them an email. You may invite them to lunch. You may pick up the phone and have a call. You may send them a book that the two of you are talking about. You may go to a certain meeting that you're both in together, but you figure out a way that every month for that year, they're on your list and you're actively doing something. And so I heard that, and even being an experienced schmoozer, it made me pause. And I thought, that's a great idea, right? So for example, when I invite you, you're coming, I think in 2 weeks to be a guest lecturer in my class, I'll be posting that on LinkedIn, as you know. Why? Well, it gives me both a little bit of press about what I'm doing. And then it also links me to you. And then I'm linked to everybody on your LinkedIn website. So I'm getting a little bit more savvy about how to use your marketing time. And that's just something that comes naturally. I enjoy teaching. I enjoy having you as a guest lecturer. So I'll call that a win-win. That's something natural for me. Going to lunch with people you like, that you don't get to see all the time, that they don't know what's happening, how you're expanding your firm, where you're going. That's important to do. Going to an SFTLA event or Alameda County or Marin County Bar Association installation dinner. Those are important because it gives you a large group. And I don't love large groups. I love one-on-ones, but you can do that there. So it keeps you present. You go, sometimes I'll bring a business card just because it forces me to give it to someone, right? Mm-hmm. So you just have to be systematic, consistent, and creative about how you go about telling people about your business.
At a certain point, you pivoted yet again, and that makes it sound like you're jumping around. We're talking about decades of practice, decades doing some defense, decades doing some plaintiffs, and more recently you have leveraged that knowledge that you had and gone into mediation. And I want to ask a little bit about how you decided to move from being, in essence, an active trial lawyer to being an active resolver.
So I have had 3 pivots in my career. First from insurance defense to plaintiffs, and then from plaintiffs to mediator. And they all seem to happen kind of organically. When I went out on my own, 2017, I decided, because I can get bored, I decided that I wanted to start doing more mediations. I had always volunteered with the courts, both San Francisco and Marin, doing their mandatory settlement conferences and arbitrations. So when I went out on my own, doing the plaintiff side only, I thought I might just start doing some mediations and seeing about it. And so in June of 2019, I had heard of an advanced mediation course at Harvard. Of course, I never had the beginning course. I had to talk my way persuasively into that course. And I went to it. It was just a week long. And I loved it. I was learning all the terminology that you'll hear mediators use, like a BATNA or invert or all these terms that I was already kind of doing naturally. And what I took away from the course was, this is really interesting. It's all psychological and there's a process for it. And I think I'm persistent and I would be really good at this. So I came back. I had one case that I had mediated right before that didn't settle, my first one that didn't settle. And I realized so much. I realized I did everything wrong. I had done it at the defense counsel's office. They had a very large conference room with glass, so you're like in a fishbowl. It was a products liability case. They had 8 people in the conference room, including Lloyd's of London, who flew out from New York. They had their own expert sitting there. And when I asked for a room for the plaintiff, they had given me almost a closet, windowless closet. And it was a very proud Croatian marble owner, marble slabs. And the yard next to his or adjacent to it was a junkyard, salvage yard. And they had a hydraulic hose that had broken and it sprayed oil all over his beautiful marble slabs, hence the lawsuit. So here's what I did wrong. I didn't control the environment. They were put into this small room for all day. Every time the plaintiff and his counsel had to walk to use the restroom or get food, they walked by that glass fishing bowl where I was stuck listening to their expert drone on. So I hadn't given them accurate expectations of how long I'd be in the other room as well. Ego was very fragile in both rooms from the owners of both businesses. And, there's just certain things I realized that optics matter. This is what I learned when I was in my course. When you take a course in mediation, you're doing your own in-house exercises. And so you learn that if, like one time I played the plaintiff and I realized I don't like how long the mediator has been talking in the other room. I don't like this. I'm getting a little pissed off. So I came back from having done this course and I just said it was my fault entirely, talked to the plaintiff's counsel, and within 1 week of playing phones, we got that case settled.
Wow.
So it was a really important lessons, a lot of lessons for me that I learned in that. And so after that, I started doing about 3 years of part-time my mediation practice, part-time my plaintiff's practice. And then at the end of that, I realized a few things. I don't know how much longer I can do this where the carriers won't be upset that I'm on the plaintiff's side. Number 2, my younger daughter, Danielle, announced that she was pregnant with her first child and be my 3rd grandchild. And I kind of realized, something's got to give. I've got too much that I'm balancing and now's the right time. And so I decided, ADR, Joanna Barron very graciously invited me to join them. And I decided, I think I need to do this. So I closed my practice in a month and a half, which was unbelievable. It was a very hard moment to close a practice. And I just started teaching and then I was starting the mediation practice, but now all is good. I'm on the other side of that.
Thank you for listening. And please join us next week as we continue this conversation. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.